Hi, everyone. I thought I would address some injunction questions, but first I thought I would tell some what I would call war stories. That is, I've been involved in real cases involving injunctions in a number of different areas. I sat down and I made a little list. I was involved with a case where someone was seeking an injunction against two people that had formerly worked for a business and had signed what's called a non-competition agreement or non-compete agreement. And they were going to start their own business, and there was a request to stop them from doing that. I was local counsel once for a temporary restraining order against a veterinary school involving students whose religious beliefs would not permit them to kill animals, and they treated surgical practice on I don't remember what the animal was, but there was surgical practice on live animals, and the animals weren't going to survive this practice. So that was another temporary restraining order issue. Once involved with a TRO on prison conditions and the transfer of a person from one facility to another. I've been involved with a temporary restraining order issue involving police picketing, and I've been involved in a number of cases involving custody matters where parents seek to remove a child from either the state or the country, and each of those always involved TROs. Some of them will give you a better sense of how it all works. For instance, with respect to the employees who had previously worked for a company, they were going to start their own company. They get a call from a lawyer who says, you better get a lawyer because I'm going to appear before a judge today at 4:30. These folks come see me about 2:30, and they tell me a little bit about their case. There is a non-compete agreement, but they claim they're not violating the terms of it. And basically, I get in my car and I drive to the courthouse and I appear before the judge. The other side has prepared all their paperwork. They have affidavits in support of the temporary restraining order, and they have made a case for a TRO. They claim that their customer lists are irreplaceable, and to lose the customer lists would be irreparable harm to them. And I kept trying to interject that, well, this doesn't seem fair to me, Your Honor. I don't have witnesses to present at this time, and I've not seen these papers until literally 7 or 10 minutes ago. And repeatedly, the judge would say, Mr. Freeman, you'll get a chance to bring forth your proofs at the preliminary hearing on the preliminary injunction. And the judge granted it, but repeatedly told me, don't worry, bring your witnesses for the preliminary injunction hearing, and we'll certainly hear everything. So it made me do the research further, and I realized, at this preliminary injunction hearing, I'm going to be able to present everything that's going to rebut it. And accordingly, the court ruled that they were not entitled to a preliminary injunction. So the question is that Rick brought up in his posting was, what is the standard at the preliminary injunction stage on the likelihood of success? So I can answer that question by dealing with my prison conditions case. I got a temporary restraining order against a state, and it would not permit them to transfer someone from one facility to a facility that was considered worse unless they gave them a hearing, and they weren't allowed to do that for almost a period of a year. And the court was convinced that a circuit court decision was controlling in the case and believed that that supported my position. About 9 months into the case, the United States Supreme Court decided a case that went to the other side, and shortly after that, the other side, the state, came before the federal judge where we had gotten our preliminary injunction and said the likelihood of success now is different because of this decision. And they were accurate. That was correct. And the judge eventually dismissed the preliminary injunction. So it happens. I was also asked a question about are injunctions ever issued in labor matters, in other words, where there's a strike. And I was involved in a case where police picketed a landfill where a town who they were employed by would drop off would bury their trash or whatever they do at landfills. And what they were doing was holding picket signs and walking across the roadway where the trucks would come, so the trucks wouldn't cross that picket line. They were not on strike, by the way, and we were able to convince a court that that effort was not a labor dispute. It was a labor dispute, but it wasn't a strike, and if it's not a strike, they shouldn't be interfering with other union employees. So the court ordered that they had to stand so many feet away from the entrance to the landfill, and basically that ended the difficulty, and we had gotten our TRO and eventually a preliminary and eventually a permanent injunction. So what I wanted you to get out of that was that oftentimes when you are asking for the preliminary injunction, the temporary restraining order, I'm sorry to keep shifting those back and forth, the temporary restraining order, the other side may not have notice until you call them. When you appear before a judge seeking a temporary restraining order, the judge's first question will always be, have you notified your adversary? And if so, what did you do to notify them? Oftentimes you'll have to submit an affidavit indicating what you did to tell the other side about this case. It could even be telephonic notice. I have had cases where I've called the other side, many cases actually, not many, but maybe two handfuls of cases where I've called the other side and said, at 4:30 today, I'm going to appear before a judge seeking a temporary restraining order against your client, whatever, explaining it. And accordingly, the other side really doesn't have a lot of time to prepare. And if you're seeking the temporary restraining order, that's good. What is irreparable harm? Usually it has to be shown that it's difficult to assess damages for the loss. The best example I could give you would be for a historic home. The historical home may not be able to be replaced. And if it's irreplaceable, that's probably what irreparable harm is. To give you an easier one, I have an old car. If my car were threatened with being destroyed, I don't know how I could call that irreparable harm. There are many places to look that would say, well, to replace this car would be $3,000 or what have you. So that's usually the way in which irreparable harm is determined, and from the examples I gave you would be the way the likelihood of success would be determined. One of the other important things with respect to TROs or preliminary injunctions or permanent injunctions is once you get a TRO, preliminary or permanent injunction, you really have to be careful that you do serve it on the other party. In fact, in the police case, a person that I worked with had to go and read the order to the officers that were marching back and forth with their picket signs. They said a lot of unkind things to him, but that was the way the order said that it had to be delivered. So service of that is important. The service of the injunctions is important. Service meaning delivering it to the other side so they know there's an injunction, is because how does a court enforce their power? That's right, by the contempt power. So that if someone doesn't honor the injunction, you can file a request for a contempt hearing, and a court can bring them before the court and find out why they have not abided by the injunction. And last but not least, I wanted to show you the broad sweep of injunctions, looking at this image of the citywide gang injunctions of the Los Angeles Police Department. In juvenile justice, I teach a little bit about the use of injunctions in California and particularly in Los Angeles. They found that if they kept arresting people and charging them with different sort of quality of life offenses, blocking streets or blocking corners or loud noisy parties or loud, threatening behavior, they felt that that was a revolving door. So what Los Angeles County did was identify gangs, identify their locations, come up with a list of things that they were doing that were violative of people's rights and get injunctions against gangs and all its members, so that when there was a violation, they felt that the contempt power was easier to use and could be used against more people. So gang injunctions are a big deal. I bet that'll raise a lot of questions. I don't want to address a lot of questions to it because it'll get us on a side ramp, but gang injunctions are one of the clever ways that people are trying to use that sort of an injunction. That's all for now, everybody. We'll be back to deal with some more of these, I'm sure. But that's my first run at it. Thank you.